Welcome back to the second segment of this law session on the common law and its development. Now, the idea of this particular law session is to give you some grounding in what you are about to study. Because the common law, as I say, is about a unique system which operates from the mother of all common law jurisdictions, England. Now, the idea is we looked at what is law and we've looked at what the idea, or we've started rather looking at what the idea of the common law is. Now, going back to the English legal system as it relates to the framework, when you look at the English legal system, the first thing that will become very relevant for you is that within the UK, there is no codified constitution. Now, some people use the word written constitution. At your level, I suppose you can, but I would rather you stick to saying there is no codified constitution, because you are studying law and the devil is in the detail. And the fact of the matter is that it's not that England does not have a written constitution, because written denotes that it's not written down, when in fact there are various things which go towards being a source of the constitution, not least Act of Parliament, which are of course written down, but it lacks a codified constitution. Now, whereas we see most other Western democracies having a codified constitution, the fact that the British Constitution is not to be found in a specific document does not mean that it has no constitution at all. If a country has rules about who holds the power to govern, what they do and cannot do in terms of power, so how that power is to be passed on or distributed or transferred, then it has a constitution, even though there is no single constitutional document. Because what is a constitution is not necessarily defined as a single document. A constitution is about rules. So when you look at, for example, a constitution of a company, a constitution of a group, it talks about the rules which define a group. Now, when you look at a constitution in respect of a country, it looks at rules relating to the organs of the state, being, of course, the executive, the legislature, and the judiciary, as well as how those organs deal with the citizen. Now, in most Western democracies, you will see, of course, a codified document which says this. But in the UK, you will find these various things, who can become a member of parliament, rules relating to human rights, are all in Acts of Parliament. So by and large, it does have a constitution. So in Britain, the constitution sources are from various quarters, not least Acts of Parliaments, as well as judicial decisions, which are written, but they are not together in one document. Now, there are also some unique, quirky things called conventions. Now, conventions are not laws, but they are rather long-established traditions which tend to be followed. Now, they are non-legal rules, but they are, by and large, followed. Now, there is no legal sanction which normally flow from them, and so you will tend to find, for example, that certain powers of the crown will, of course, be exercised in a particular manner by convention. So to give you an example, the Queen, by law, is the one who chooses who will, for example, be the next Prime Minister. So she could legitimately say Jennifer Housen can be the next Prime Minister of England. But the non-legal rule, meaning the convention, which says that the person who is to be the Prime Minister, by convention, the Queen's choice or the Crown's choice, will be the person who has won or whose party has won the election and he's the head of that party. By convention, that's who she'll choose. But legally, she could choose whoever she likes. Now, when you look at things like prosecution and verdicts in criminal trials, this is all part of this seamless web of the common law, Because when you look at the idea of trial by jury, you're seeing a body of persons sworn to give a true answer or verdict to some questions. Now, this became one of the most distinctive aspects of the common law system. Now, the 20th century has seen, and certainly into the 21st century, we have seen a marked decline in the role of the jury, and what we see is an almost total disappearance from civil trials. And also, there's been this whole discussion about the removal of juries from certain types of criminal trials. Now, when you look at the English legal system and its uncodified constitution and rules like conventions, we see a clear difference between the English legal system and, let's say, continental Europe civil law system. Now, there have been numerous movements to codify the common law, but without success. What you have instead is a tradition which is dominated by judges. Now, in the English tradition, the judges are considered, in the words of Blackstone, the living oracles of the law. Now, the English common law was the handiwork of judges, and judges have put a gloss on certain cases in their judgments, and it is this refinement over time, taken into account contemporary issues, that have shaped and developed the common law. Now, we see things like the 1966 practice statement, which says that the House of Lords doesn't bind itself, for example. Now, when you look at that, it allows the law to breathe, meaning that the law can develop, and whereas something may have obtained in previous years, contemporary society may feel that this is no longer the case. Now, a classic example is the situation in England and Wales, where it used to be that if you had a situation where you had a type of case where it's not negligence, but if it was what was called intentional injuries to the person, you could not extend the time of limitation, meaning I am supposed to bring an action against you within a certain time. So let's say 1 year. If it's an intentional injury, you punch me, it's not an accident, you do it deliberately. The law says I have a year to bring an action. But if you negligently passed me and I fell over and I hurt myself, I can bring my action within 3 years. Now, it was the case in England and Wales that the court, the law did not provide for an extension of the time limit when somebody didn't bring their action in time. Now, in a famous case called A and Hoare, Hoare, we see where a situation where this man, Mr. Hoare, had been convicted of rape, and he had been jailed. He subsequently won the lottery whilst he was on day release, and the question was whether or not his victim could bring an action in order to get monies from him through a civil case. And the point was made that although the time had passed, and this was a deliberate action which was not negligence, because the court had the ability to extend time when there was negligence, but it didn't have the ability to extend time if it wasn't negligence, the court actually went along the path of saying, yes, time could be extended. And they moved away from where the position had been in previous case law. What does this mean for us? It shows that judges will, of course, put a gloss on the cases, and certainly the courts will look at contemporary issues in determining their judgments. Now again, unlike the continental European system, English law was based on custom, and it sits on the whole idea of precedent. So we see judges reconciling precedents in practice, And what we see is that the judges will follow a case or distinguish a case or overrule. But the whole idea of precedent is that if there was a case similar to this before, the judge will follow that case. Now, in continental Europe, that's not the case, because when you look, for example, in the English legal system, if you've got a case like, and you will learn one in contract, let's say Carlyle and Carbolic Smoke Ball, if you had the exact same facts today, the courts will say, well, precedent says this is what we have to do. Whereas in continental Europe, that's not the case. You could have 10 cases with the very similar facts of Carlyle and Carbolic Smoke Ball going before 10 different courts, and each of them considering each of those factually before them. Well, it's a matter for you to determine whether or not you think this is better or not. Now, persons wishing to become lawyers did not go to universities at the time to study textbook. Rather, they lived in one of the inns of court, where they listened to barristers and judges and learnt the law by seeing it in action. Now, it is interesting, and certainly for those of you studying on the University of London Law Degree Programme, it is noteworthy that the University of London was the first university to create a Bachelor of Laws, the LLB or Legum Baccalaureate, as an undergraduate degree in the 1890s. Just a bit of trivia there. When you look at the English legal system, it is the original common law system, and the common law of England has come out of over 100 years of development. Now, over the subsequent centuries, it has grown through complex processes of recognizing and rationalizing the multitude of judicial decisions that the judges of the central courts have created. Now, when we look at the rise, and some might consider fall, of the English law tradition, we need to look at it from an historical perspective. Now, the common law is often referred to as a tradition. Some refer to it as a mystery, growing organically or inherently irrational, defying logic, and chaotic. It is sometimes amusing, for example, to see how the rules of the common law are greeted with complete horror in civil law jurisdictions. And I do remember even discussing the law with somebody from a civil law jurisdiction. We are trying to explain the concept of that occurs in criminal law, where you do not have any obligation, or the criminal law will not attach liability to you if, I am standing here and I see a 2-year-old drowning in a paddling pool, which I could just reach over and save that child. The law does not consider that I have a duty to which criminal liability would attach. But when you look on the continent, there are countries which say that is just absolutely morally abhorrent, and so it may even give rise to criminal liability. Well, there's no such duty in the English legal system. What we see is the common law system is best understood as a historical creation with features that may reflect the contingencies and arguably accidents of history rather than any rational design. There's this development which has taken on board things that have happened along the way, as it were. Now, in contemporary society today, we see statutes having a far greater expansion. They have risen in importance. And when you look at the old traditions like oral pleadings and the adversarial style of legal proceedings, you see that a lot of these have pretty much, as some commentators say, been the end of the common law system. And certainly Baker, writing in 2002, has referred to this. Others, though, have stressed that the adaptability and organic nature of the common law tradition as seen as, or rather ensured, that when you look at it moving forward into the future, there seem to be positive integration with other traditions. We're going to take a brief break again. I will continue with the historical perspective of the development of the law of England, and we will look at the traditional picture and certainly again explore this background as to where we are today in terms of the common law.